Welcome back, everybody, to another shocking episode of Lockdown 23 and 1. That's right, shocking it is, ladies and gentlemen. Today we're going to be speaking about Jose Morales, who was found guilty for the murder of his own girlfriend. Not to mention, as always, we're going to jump into the courtroom and witness him get sentenced for these crimes as well. And it's in a courtroom that I don't think we've ever been in. Connecticut. Yep, that's right. We got some traveling to do today, so go ahead and slap on those khaki and blouses. The courtroom's calling our name, but first, as always, if you're new to the channel and enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today. A jury found Jose Morales guilty of murder of his girlfriend, Christine Holloway. Police found Holloway's body on December 2nd, 2019 in her home at Myrtle Avenue in Ansonia. The couple's daughter, Vanessa Morales, was 14 months old at the time, and she was not in the home when police found Holloway. And unfortunately, there's been no sign of her since. Very eerie situation, not to mention what Mr. Morales says happened to the child. But Morales, 48, was arrested in connection with Holloway's death February 7, 2020. Prosecutors said he hit Holloway at least 8 times early in the morning of December 1st, 2019. It said that Holloway was beaten so badly that most of her brain fell out of her cracked skull. 5 of her ribs had also been fractured. Her cause and manner of death was listed as homicide by blunt force trauma. Detectives also recovered white solid fragments from the garbage disposal in Holloway's kitchen. Those turned out to be bone fragments. Prosecutors also said that Jose Morales then spent 37 hours trying to clean up and dispose of the evidence before fleeing and leaving Holloway in the bathtub. Morales actually testified in his own defense and said 2 men broke into the home, killed Holloway, and kidnapped their daughter while he was high on PCP, which is also known as angel dust, and he could not help them because of the effects of the drug. And that story, ladies and gentlemen, the jury did not believe. They found him guilty, I believe, in less than 4 hours. And we're going to witness that guilty verdict in the courtroom, not to mention, like I said, the sentencing. But it continues saying he also testified that one of the men told him that his daughter would suffer the same fate if he called the police. The attorneys delivered their closing arguments on Monday, the 10th day of trial, and the case was then turned over to the jury to decide. The jury reached a verdict after around 3.5 hours of deliberation.
The first count of the amended information charging the defendant Jose Morales with the crime of murder in violation of Section 53A-54A of the Connecticut General Statutes, how do you find the defendant as to the crime of murder?
Guilty.
In docket number ANCR 20-018-66660T.
Oh man, his eyes are closed, but if I were to guess, his whole life's flashing before him. And look, one of my many talents I like to take pride in is put myself in other people's shoes. And even though I've been in and out the courtroom and convicted 99% of the time by a wide variety of judges, me personally, if I was found guilty for a murder that I didn't commit, I'd be snapping in the courtroom like, you f***ing jurors don't know shit. There ain't no evidence showing nothing. Is it because I'm mocha latte?
In the second count of the amended information charging the defendant, Jose Morales, with the crime of tampering with physical evidence in violation of Section 53A-155 of the Connecticut General Statutes, how do you find the defendant as to the crime of tampering with physical evidence? Guilty or not guilty?
Guilty.
Verdict be accepted and recorded.
Court will order the verdict accepted and recorded, Madam Clerk.
And now we're going to roll into sentencing and witness what the judge has in store for Jose Morales.
The defendant has been convicted of murder and tampering with physical evidence by a 12-person jury. I did hear a plea to the court by defense counsel regarding PCP use. Intoxication was presented to the jury. It could have been relied on in terms of reaching that intent element of murder and tampering with physical evidence, actually. And the jury did move forward with convicting the defendant of murder and tampering with physical evidence. Now, in anticipation of sentencing, the court has reviewed the pre-sentence investigative report, my notes on the evidence, and the verdict. The court did hear the same evidence as the jury, and that evidence supports the verdict. In imposing sentence today, the court does consider a number of things, which the court will take the time to highlight for purposes of our record. The pre-sentence investigation report by probation, in which the officer recommends incarceration only. The court also considered the information contained in the pre-sentence investigative report, looking for mitigation. I will highlight some of the information from that report for the record. The defendant's age, now 48 years old and around 43 at the time of the murder, and tampering with physical evidence. The court has considered the defendant's family background as described in the PSI report, including the makeup of his family, his childhood experiences, and the relationship that he has with his mother, stepfather, and living brother.
Look, it's almost identical to your credit history when getting sentenced in the courtroom, except they're looking at all your past bad deeds. And depending on the crime and how severe it is, when it comes down to sentencing, you heard what they said. They go all the way back to when you were a child. It could have a big factor in how much time you get in prison.
The defendant reports, and the court will acknowledge perhaps a difficult upbringing in that his father, who was killed when the defendant was 11, although nice to him, was apparently not so nice to the mother and older brother. The defendant reports his childhood overall as good with ups and downs. His mother always has been supportive and loving. They do have a good relationship, and the stepfather has become his psychological father. His mother and father still support the defendant, believing in his innocence, although acknowledging their love for the victim and expressing the amount of suffering all family members are currently going through and have been going through for many years. The court notes that the defendant reports a history of PCP use back to 1993 with sober periods and periods of relapse, and a last reported use in 2019. The PSI also documents intoxication and marijuana use at an early age and the use of illy back in 1994 before completing a 6-month drug program during a prior period of incarceration with outpatient treatment during a period of parole. The court will also note, however, that the court has no evidence in the trial, aside from the defendant's testimony, of any PCP intoxication at the time of the murder and the tampering of physical evidence in terms of laboratory results. So the evidence was limited to the testimony of Mr. Morales.
And if I were to guess, he's going to be appealing it off of that alone. He probably thinks it's a big factor when persuading the jury members, but if I were to guess, high or not, it doesn't matter, man. He's going to Smokeville.
With respect to medical and mental health of the defendant, the report indicates some childhood mental health therapy, limited treatment for anxiety, post-traumatic stress disorder as an adult, but nothing ongoing and no definitive diagnosis noted from any medical or mental health provider by the writer of the PSI report.
So that means he's fully capable to get engulfed in smoke. Bobby, cue it!
The court has considered the defendant's work experience and educational background. It does appear from the report that the defendant did hold employment for some period of time prior to being incarcerated, and also that he did complete high school and started college with no degree. Court notes the defendant's prior criminal history, which includes domestic violence with a felony conviction for violation of a protective order in 2012, failure to comply with conditions of probation resulting in 2 violation of probations, and multiple felony drug sale related offenses with convictions dating back to 1996 and into 2000, which led to lengthy incarceration and lengthy periods of special parole. This court has carefully listened to the statements of Christine's Aunt Anna, Jody Jacobellis, Christine's brother's fiance, Christine's best friend, and Stephen Holloway, Christine's brother. I've also listened to the statement read into the record by Mr. Holloway from Christine's mother, and I have read the written statements that were provided to the court by way of the pre-sentence investigative report. I've considered the comments of the state's attorney, defense counsel. I've reviewed the certificates provided by defense counsel concerning the defendant's completion of certain courses and instruction during incarceration. I do want to acknowledge the difficult task it must have been for family members to give a statement to the court. Those statements were extremely emotional. I can't imagine how you feel, but I do recognize what you have been through over the course of many years to get to where we are here today, and the difficult task it must have been relaying how you felt to the court just momentarily. I want to let the record be clear of a few things. This court has not considered any statements or information provided to this court during this sentencing proceeding relative to any correlation between the defendant and missing child Vanessa Morales. The court recognizes its limited role in this particular sentencing proceeding on the guilty findings of murder and tampering with physical evidence. The sentence imposed will reflect the court's findings relative to solely those charges. I also want it noted for the record that multiple members here in support of the decedent have come into court today with T-shirts that depict the face of Christine Holloway. That is your right to do so. I did not preclude you from doing so, but I will note from the record that the court was not unduly influenced by that display on your apparel.
Wow, the judge is really precise, hitting every avenue. No loopholes gonna be coming around these corners.
Sentencing in a case such as this is a monumental task for any judge. The court must consider the goals of sentencing, which include, among other things, the court's obligation to impose a fair and just sentence, which enhances the public safety, holds the offender accountable, affects general deterrence in order to reduce criminal activity and promote rehabilitation. In doing so, the court also considers the seriousness of each offense and the facts established at trial. I'm not going to restate all the testimony and evidence that was presented during the trial of this case, and I do wish to spare the family members of any additional pain. However, I must comment briefly on the evidence that the jury heard for the benefit of any future proceedings.
Now, if you weren't paying close attention, might have walked away from the screen, listen closely. The Honorable Judge is going to break down exactly what evidence got him convicted.
It was established beyond a reasonable doubt, our highest burden of proof, that the defendant specifically intended to kill and did in fact cause the death of Christine Holloway. It was further established beyond a reasonable doubt that the defendant intentionally tampered with physical evidence relating to the homicide of Christine Holloway. The evidence presented to the jury established that Christine was only 43 years old when her life was needlessly and violently taken from her at the hands of the defendant. This was not accidental, as the jury found, but rather intentional. It was a gruesome, intentional physical attack on Christine. The evidence that the jury heard included multiple blunt force injuries to Christine's head and neck, including skull fractures with a minimum of 8 blunt force impacts, leaving behind a horrific crime scene full of blood and brain matter and the lifeless body of a young mother, sister, daughter, co-worker, and friend. In lieu of calling the police or contacting anyone for help, the evidence presented to the jury indicated that the defendant stayed at the apartment, attempted to clean the bloody mess on the floor, discarded brain matter in a sink, and collected and discarded other evidence with blood on them at a donation box. In fact, bags of physical evidence, including children's toys splattered with blood, adult clothing, and other objects, all while leaving the lifeless body of Christine Holloway in a bathtub back at the apartment.
If I was a jury member, the only evidence you need to show me to lock it in is him trying to clean up evidence for 36 hours after the fact. Normal people call the cops immediately, especially with their child missing, right? So this dude, if I were to bet it all, is guiltier than sin itself.
Christine's body was left in a bathroom bathtub with candles lit and a skylight open. The defendant fled the scene. The defendant did take the stand in his own defense, telling the jury of drug use and unknown intruders, and how one of those intruders struck Christine multiple times with a crowbar and one took his daughter and ran out the door. A jury of 12 rejected his account of what happened to Christine, and the jury's findings are supported by the evidence. To the victim's family members and friends, thank you for your patience with this process, which admittedly has been extraordinarily long to bring this case to conclusion, and most certainly very difficult to endure. Although a conviction and sentence cannot bring back your loved one, I hope that it will provide some closure as to the investigation into Christine's death and open a path to the healing process, which I'm sure will be a lifelong process for many, if not all of you. I have heard through your statements and your letters to the court, which have provided a sense of life to Christine here in the courtroom. I understand how you feel today, how you've felt for many years, and you've given the court some indication of the type of person that Christine was. The impact of this crime, of the defendant's conduct within our society is profound. A vicious crime such as this severely impacts the overall feeling and safety in our society. Society should not have to fear such careless indifference to human life.
Nope.
It makes you question who really lives next door to you.
Yup.
Christine had the right to be safe in her relationship with her young daughter's father, safe in her own home. This was a cruel, intentional, senseless, violent act. The defendant must be deterred from ever committing such an act again, and the sentence imposed must reflect the court's intention to deter generally such violent, senseless acts from happening in our society. The facts of this case, along with your criminal history, Mr. Morales, leave this court to believe that you have no regard for the rule of law and a callous disregard for human life. Your record clearly establishes that prison sentences, probation, and special parole do not dissuade you from committing future crime. Any consideration to be given to the aspect of rehabilitation in this case pales in comparison to the severity of these crimes. Mr. Morales, you are a dangerous person, a significant threat to society, and you need to be removed from the community for a substantial period of time. The victim's family, as well as the members of society, expect the guilty to be held accountable for their actions and rely on the criminal justice system for some measure of closure.
Yep.
No sentence or comments by the court will lessen the profound sense of loss caused by your actions. But you, Mr. Morales, will be held accountable and sentenced accordingly. Mr. Morales, please rise.
Bobby!
Please stand up.
Upon the court's considerations as outlined on the record, the following sentence is hereby imposed. As to the finding of guilty of the crime of murder of Christine Holloway, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 60 years to serve, which in accordance with our statutes is defined as life. As to the finding of the crime of tampering with physical
60
evidence,
clip.
it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 5 years to serve, to run consecutive to the sentence on the murder, for a total effective sentence of 65 years to serve.
Well, there you have it, ladies and gentlemen, 65 Blickums. How much time will he do off of that in Connecticut? Because, you know, most states give a little bit of good time. It says here in Connecticut, good time credit can reduce an inmate's sentence. It says for sentences up to 5 years, inmates can earn up to 10 days per month, which means 10 days reduced from their sentence. For inmates with longer sentences, if I were to guess, like the individual we've seen today, they can earn up to 12 days per month. So times that by 12, and then, you know, times or divide by 65 years, subtract that, and you'll get the amount of time that he's going to get. Look, I'm not no mathematician, but some of y'all are, so go ahead and do it and lace up the comment section for the ones that ain't. But there ain't really too much to learn from this one, you know, not too many of us are out there killing people. But if you are, look at this guy, chances are you're going to get caught up, and straight to Smokeville you go. And more than likely, depending on the victim, the inmates are going to be waiting to make you theirs. But hopefully you enjoyed. If you did and you're new to the channel, tap that like, subscribe, notification bell before you leave. And more importantly than anything, y'all be easy, be safe, and stay free.